The 1980 Hague Convention established an international legal process for cases in which a child has been wrongfully removed to another country or retained there without the consent of the other parent. Brazil is a party to the convention. This video explains, in general terms, how a return case develops from the initial application and judicial review to the final decision on whether the child must return or may remain. Start with the thing that surprises most people. This case does not decide custody. It does not decide who's the better parent or where the child should grow up. It answers one narrow question. Should the child go back to the country where the child was living so the real custody fight can happen there? That's the question. That country has a name here. It is the country of habitual residence. In plain terms, it is where the child actually lived and had a normal life before being taken or kept away. Not where the parents come from, where the child's real life was. How does a parent ask for the child back? There are two ways. The first is through the central authority. Every country in the treaty has one. In Brazil, the parent files there, and the federal government carries the case to court with public support at no lawyer cost. The second way is direct. The parent hires a private lawyer and files in court without waiting for the state. Either way, the request has the same shape. It names the child, it shows where the child habitually lived, it shows that the removal or the retention broke the other parent's rights, and it asks for one thing, the return of the child. Nothing else is being decided yet. Timing matters, and one date carries real weight. It is the 1-year mark, counted between the day the child was taken or kept and the day the case begins. If less than a year has passed, the rule is simple. The child should be returned, unless an exception applies. If more than a year has passed, one extra question opens. Has the child already settled in the new country, with a new school and a new routine? If the child is truly settled, a court can decide the child stays. Time is never on the side of waiting. What are the exceptions? They are narrow. They exist for real problems, not for ordinary disagreements. The main one is grave risk. A child does not have to go back if returning will put the child in serious danger of harm. Another is the child's own voice. If the child is old enough and mature enough and firmly refuses to go back, a court can listen to that. There is also consent. If the parent asking for the return had agreed to the move or accepted later, the case can fall apart. And in Brazil, since a Supreme Court decision in 2025, domestic violence against the mother can be enough to keep the child here, even when the child was not the direct target. Danger to the home is danger to the child, but every exception has to be proven clearly inside the case. Without proof, the return goes forward. Once the case is filed, it goes to the federal court and it's meant to move fast. These cases carry priority. They are not supposed to wait in line behind everything else. The treaty sets a target. It asks courts to decide within about 6 weeks. That is the goal on paper. In real life, in Brazil, the first steps before the judge take around a month to get moving, and the full case runs longer than 6 weeks. A realistic picture from filing to a first decision is often several months. In many cases, the judge orders an expert evaluation. A psychologist or a social worker looks at the child and the family and reports back. This matters most when there is a claim of risk or a question about where the child is settled. It adds time, but it gives the judge solid ground. Then comes the decision. the judge orders the return or refuses it, based on the habitual residence, the 1-year mark, and in any exception that was actually proven. The decision can be appealed to the higher federal court by either side. This is often where the real time is spent. Here's the fair expectation. The treaty wants these cases closed quickly. In practice, a full return case in Brazil with an appeal can take up to about a year, sometimes more. Faster is possible, slower happens, but the direction of the treaty never changed. Decide and decide soon. If the final decision is for return, the child goes back to the country of habitual residence and the custody case is decided there. If the parent does not comply, the court can enforce the order and the federal police can help carry it out. That is the whole path. 2 ways to start, 1 narrow question, a short list of exceptions, a court built to move fast, and a decision that sends the custody fight back home. Understanding that path before you take a single step is the best thing any parent in this situation can do.